Good afternoon, everyone. Thank you for joining us for today's webinar on confidentiality and privilege. My name is Brooke Meyer. I'm the director of the Institute for Coordinated Community Response, and we're so glad that you're with us today. A few housekeeping items before we begin. Please be sure to use the Q&A box at the bottom of your screen for any questions that you have throughout today's presentation. It really helps us keep track of questions so that we can save them for the end during the Q&A portion. If you'd like to make comments or otherwise interact with presenters and attendees throughout the webinar, be sure to select all panelists and attendees in the chat box so that everyone can see what you've written. If you have any technical difficulties, you can message only all panelists and ICCR staff will assist. And just a little background on the Institute for Coordinated Community Response before we begin. Created in 2018 as a program of the Conference on Crimes Against Women, ICCR is a training and technical assistance program that works with rural communities to improve their systemic responses to domestic violence. We work with teams made up of law enforcement officers, prosecutors, and advocates from rural Texas counties each year to take a deep dive into their current criminal legal response and begin building the scaffolding for a sustainable CCR. In addition, we host regular trainings like this one, both virtually and in person, to ensure that rural communities across the state and the US have access to the most relevant cutting-edge training on domestic violence dynamics and collaborative solutions. And while our program is geared towards rural needs, through webinars like this one, we're able to train practitioners from all over who are committed to eradicating domestic violence. So again, thank you for being with us today and for being dedicated to this issue. You can learn more about ICCR on our website, instituteccr.org, and I encourage you to sign up for our newsletter there to stay in the loop about all of our upcoming trainings and events. And speaking of upcoming trainings, we have several both virtual and in person. On the screen now are our upcoming virtual trainings. On the 16th, we will have a webinar specifically about conducting focus groups with community experts and system practitioners and how that can really inform your CCR work. So be sure to join us for that one. And on November 17th, we will have our next Rural Texas Advocates Call. This is a bi-monthly call that we host for any advocates serving rural Texas, even if your main base is in a slightly larger area, for peer support and networking and education. On the November 17th call, we'll be diving deeper into Q&A surrounding privilege and confidentiality specifically for advocates, so be sure to join us then. And then we also have several upcoming in-person trainings throughout November and December. You can see on your screen where each of these is being held. So if you are close to any of these locations, please feel free to join us. They are all free and lunch is provided for all of these trainings. And again, you can visit our website, which is at the bottom of your screen, instituteccr.org/upcoming events to register for those. And now I'd like to introduce today's presenters. Breall Baccus is a public policy coordinator at Texas Council on Family Violence. Her particular work focuses on training and technical assistance on issues including privacy, technology, and data collection. Other professional passions include supporting college student survivors, prevention, and systems change to center the needs of survivors. Elizabeth Boyce is the General Counsel and Director of Policy and Advocacy at the Texas Association Against Sexual Assault. Liz has advocated for survivors for over 20 years, both in private practice and at nonprofit organizations such as the Texas Advocacy Project and Texas Legal Services Center. At TAASA, she directs the Policy and Advocacy Program, advancing the public policy interests of sexual assault survivors through research, education, lobbying, advocacy, and grassroots organizing. And last but certainly not least, Molly Voyles is the interim public policy director for the Texas Council on Family Violence. And she's worked at the coalition for 15 years and in the movement to end violence for over 25. In her position at TCFV, she provides technical assistance and training on a variety of issues, including supporting survivor-centered systems, promotion of housing access, and privacy supports. She is focused on public policy efforts that center the needs of survivors and advance systems change. Breall, Elizabeth, Molly, thank y'all so much for being here. Please take it away.
Thank you so much. Thank you for having us. Thank you to AJ and Brooke for all their help so far with technology. And we are so excited to see everybody chiming in the chat box. So please keep chiming in. I'm super excited always to be with my colleague Breall, but also with Liz, because we've been thinking about privacy for so many years together. So it's very exciting to be here today to talk to you about both the family violence advocate privilege law and to have Liz here talking about their recent success around sexual assault privilege laws. So y'all are kind of getting one of our first combined presentations, which is just makes me excited. Did you know you could be so excited about privacy, y'all? You could. It's your lunch, I'm excited about privacy webinar. Breall's going to move us to the next slide because one of the things we want to acknowledge first and foremost is that while privacy is important, privacy can be hard, right? As we navigate and work with really important partners, many of whose names I see in the chat box today, we know both that privacy can be a critical component for survivors in help seeking, and also it can be challenging as we build relationships and we collaborate and we work across partners and systems. So we want to start today thinking about, we're spending a whole hour and a half. Why is privacy important? And so I know y'all came thinking, I sure hope these ladies start by asking me a question right at the top of the webinar. So I'm wondering for you and your work, why is privacy important? And we'll look at the chat if y'all want to just chime in things that have come up for you, whether or not you're in a family violence or rape crisis center, maybe you're at the district attorney's office. What have you seen be important? I'll just take a minute and let folks think on how privacy has been important to them. I'm just gonna wait for that chat, y'all. It's gonna be exciting when it happens and lights up. I'm positive about it. And Breall, I think while people are thinking about it, if you'll go forward 2 slides for me, actually, and then we'll come back 1. So kind of advance us twice. One of the things we want to kind of do is frame out what is privacy and what's confidentiality and what's privilege. So as you're thinking about it, and I'm starting to see the chat box light up, one of the things we want to start with is that privacy is a term that is best used to describe the information and how I hold it, how I share it, when I share it. So I could have told y'all my name was Molly Voyles. I did do that here today. I could have offered my middle name, right? That would be a privacy choice. Do I feel comfortable offering that? Do I not feel comfortable offering that? My choice on that, and just for a hilarious joke, one of my middle names is Elizabeth. So you already have 2 Liz's here, y'all. But I also could have said, no, my privacy says I want to keep my middle name private, right? So survivors, when they're coming for services, they choose what part of their story they want to tell us. And sometimes it's counseling services. Sometimes it's to seek specific remedies or help. Sometimes it's nothing at all, because many times when they have trusted, that trust has been broken or breached by a partner who uses violence. So we'll use privacy both to encompass that and as an umbrella term for privilege and confidentiality. Confidentiality is said really simply, it's a grant agreement you make under your Violence Against Women Act, your Family Violence Prevention and Services Act, and your Victims of Crime Act funding. When you take receipt of those funds, you agree to take responsibility for holding confidential survivor information. Privilege is a law actually prohibiting the disclosure. And so today we'll talk about kind of the shades between all of that, and hopefully have folks walk out with a good understanding of how they intersect. And so, Breall, I'll have you go back to, and thank you for being our slide mover, as you said. We're seeing people say sometimes do not wish to report their victimizations. And I think Breall's already got on the screen some of the answers. For victim safety, to help gain trust, right? And so those are huge pieces, right? Well, absolutely, safety is a humongous component of any confidentiality or privilege law, and certainly for many survivors governs privacy disclosures. So y'all hit right on safety and trust. If Breall said to me, hey, Molly, you know what, you can tell me anything and about 50% of it I'm gonna keep. The other 50%, no promises, I'm not totally sure who I'm gonna tell. I would really think twice about what I'm offering Breall. If Liz were to tell me, hey, we have this privilege statute, these are the only few times where I'm gonna release information, and anything else, it's gonna stay with me. I'm going to be much more likely to tell Liz more information because I understand and we can build trust around what I'm sharing. It also is the ability to seek services. Many times for a survivor of domestic violence and a survivor of sexual assault, we are talking about the relationships we hold in our home. We are talking about our intimate relationships. We're talking about the way I build finance, the way I parent. We're talking about who and when I choose to have personal conversations with. And that's usually all a part of seeking services, because inherent to the victimization is that personal nature. And so for me to truly seek services, I need to know when I share that information that that's the end of the line. Otherwise, I might be less inclined to seek help. And so we kind of say that at the front because we know we're going to talk about some really technical intersections. We're going to talk about where it gets tough and how we work with partners. And so as you hear any of the three of us talk today, we want you to hold that this is why we're doing all of this with survivors, is to create an environment where they can seek help, they can build trust, and they can feel safer as they do so. Breall, if you don't mind moving it to one more, and then one more, thank you. Oh, look, it's perfect timing. The other thing we want to say is, another beautiful part about these laws is they don't pick and choose who gets them. These laws, if you're at a family violence center or if you're at a rape crisis center, they start the minute you pick up that hotline call, right? So the minute I reach out for services and say, my name is Molly Voyles and here's what I'm thinking, is the start of those protections for a survivor. It doesn't matter if it's a man. It doesn't matter if it's an immigrant survivor. It doesn't matter if it's an unaccompanied minor seeking services. Our laws were meant to create that safe space. And so we offer that pretty clearly at the beginning because we know at times there'll be a lot of questions. And we are going to go over exceptions to be sure. We know some exist in both sets of our laws. Many of them are pretty complementary for sexual assault and domestic violence. But the good thing is you don't have to think, well, I'm not, they're a man, I don't think the same things apply, or it's an immigrant survivor, I don't think the same things apply. So one of the things they did is make that apply to everyone. And then the other thing, we're going to talk about a lot of statutes here today. And Breall's going to move to a little bit of an image in a minute that shows them. A lot of them at the federal level have mirror components. And we're talking about the Family Violence Prevention and Services Act, FIPSA, Victims of Crime Act, VOCA, and the Violence Against Women Act, or VAWA. So kind of cool thing with that is they conformed and made them a bit of a mirror. We're also going to talk today about the passage of recent legislation that the Texas Association Against Sexual Assault championed and Chapter 93 of the Family Code. If you are operating in a family violence center, one of the things that you often see in federal laws, a broad language either that says you will keep this information, but they don't always offer the blueprint forward on how you do it. So if you're operating in a family violence program or you're partnering with one, or maybe in your coordinated community response, that's a frequent partner. And Liz will speak on the side for sexual assault. There are regulations that also govern. And so today we'll try to weave like one narrative that helps you see that picture that all those programs are operating under, so that if you work in one, you feel a solid understanding. And if you're a partner with one, you understand some of the responses and information being offered by those programs. And again, as you'll see on the next slide, the kind of nice part in a minute when you start seeing us break down some of these provisions is that VAWA and FIPSA and VOCA create mirrors of each other in the statute. So in a minute, if you see a slide when Breall's talking that says VAWA says this, on the other hand, FIPSA does. The reason this is important is under confidentiality. If you remember, those are those terms we agreed to when we took receipt of money, then that means it's the money you took receipt of that governs your provisions on the federal side. On the state side, because it's in our statutes, you will be governed if it applies to the definitions Liz and Breall and I offer. So just kind of a clarification. We know sometimes you walk out of a privacy session and you're like, that's a lot. So if you hang on to VAWA, you're kind of hanging on to FIPSA around confidentiality. And I think with that, Breall's going to start walking you into those federal provisions before we move into our stateside ones.
Yes, thank you. So we'll jump in, like Molly said, to cover those federal provisions. Again, VOCA, VAWA, FIPSA, all mirroring each other. But when you take receipt of those funds, you are charged to not release personally identifying information that is collected in connection with services requested, utilized, or denied. And furthermore, with receipt of those funds, you are required to hold confidential the records pertaining to any individual provided domestic violence services by any FIPSA supported program. And no client level data may be shared with a third party, regardless of encryption, hashtag, or other data security measures without a written time limited release as described, which we will cover later on. So a few things to point out here. Under the confidentiality of records, that includes client records. And this is basically saying that without a release of information that's properly executed, you cannot share any personally identifying information outside of your program. The important piece of bullet number 2 here that says it's regardless of encryption, hashing, or other data security measures really comes into play when we're talking about more of the tech world that we live in now and the databases that we use to collect information. So keeping in mind that things can be secure, but that's different than things being private. So a third party includes a database vendor or other parties being able to access the information that you have stored in your records. So that's an important piece there, that security is not the same as privacy. So what is personally identifying information? This is information likely to disclose the location of a victim of domestic violence, dating violence, sexual assault, or stalking. This could be a name or address, contact information, social security information, or a date of birth. And it could be any type of information that combined makes it possible to know who that survivor is. This is really important to think about when you're thinking about rural communities, because if I'm in a large urban community, if I'm a specific religion or practice a specific religion, that might not be identifying, but in a small community that could be. So it's really not something that we can say this is the exact list of what constitutes personally identifying information. And it has to be something that you look at on a case-by-case basis to say, could this be identifiable about the person? So there are cases of when and how you can share the information, and they are clearly laid out in the federal language. That includes with an informed, written, reasonably time-limited consent from the person. So the survivor signing that form, that means that you had the conversation and they understand where that information is going and they are requesting that of you, right? Mandatory reporting is an obvious exception. Under Texas, everyone is a mandatory reporter of child abuse and neglect, as well as for the disabled and elderly. And so following those statutes is required. With a court order, you are able to share with a court order with the appropriate response. So working with an attorney to make sure that that's responded to appropriately, but releasing the information isn't the first step. And we'll talk about that more later as well. And then lastly, under the federal statute, the abusive partner cannot be the one to sign the release of information. So this comes up for some cases, for example, when a child is receiving counseling services from a family violence center, and the abuser may call and say, I want information on those services provided, but under VAWA and FIPSA, the abusive party cannot be the one to sign a release and get that information. And then we will talk more about how the state laws factor into this, and because there is more guidance around for specifically under Chapter 51 in our Texas code that outlines some confidentiality requirements for family violence centers. And then also keeping in mind that there are other jobs and other professions that may have their own type of privilege, including attorney-client privilege. Everyone's pretty familiar with that, as well as mental health professionals having their own confidentiality protections or enhanced confidentiality due to their licensure. And so while we won't touch on those, it's in depth, it's important to keep in mind that those might have some intersection with these other federal and state statutes that we're talking about today. And just, I know I went really quickly through that, and just a reminder, there is the Q&A section that you can enter a question if anything comes up, and we'll answer those at the end. But with that, I will pass it over to Liz to talk about the sexual assault privilege.
Thank you very much. And thank you all for being here and for patiently listening to us as we go on and on about our favorite topic, as Molly told you earlier. This is something that has been very much on my mind for many, many years. And so I am very pleased to be able to talk to you about our success last session in getting this passed for sexual assault survivors. Just briefly, I was already introduced, but just in case you're just tuning in late, my name is Liz Boyce, and I am the General Counsel and Director of Policy and Advocacy at the Texas Association Against Sexual Assault. And so I will talk about the basics of privilege as it pertains to sexual assault survivors. And as I said, this SB 295 was passed last session and provides a more robust protection to sexual assault survivors of their privacy rights, and it was one of TAASA's main legislative priorities, and it has been for many, many years now. So yes, next I'll go on to talk, no, if you don't mind, back up a little bit, thank you. So first, I just wanted to talk about how important it is to make the point that this bill did not create the concept of advocate privilege, because our friends at TCFV blazed that trail for us in Texas several years ago. And in fact, our government code already actually recognized that advocates do owe a duty of confidentiality to sexual assault survivors. So that was already law. But what this statute does now is to provide stronger privacy protections to the sexual assault survivors who end up in court. And this brings their privacy rights in line with that of domestic violence survivors in our state. It also follows the national trend to afford victims of rape a higher level of privacy when they are in court. So we're going to cover a little bit today about the history and intent of this change in the law, and then I'll walk through a little bit of the provisions of the government code that are set out about privilege, as well as the exceptions that exist, which were already statute, but once again, we tweaked one of them in a big way. So we'll talk about that. So moving on to history and intent, thank you. So SB 295, as I said, was authored by Senator Perry of Lubbock, and it was passed during last session. So we wanted to pass this legislation as early as 2016. We worked really hard on it back then, and we were in constant conversation with TCFV on this, but we were facing a lot of opposition from prosecutors and defense attorneys. And, you know, this was not long after the Michael Morton Act had passed. And so we were just seeing, you know, a lot of attorneys that were proactively seeking records from rape crisis centers, just to make sure, you know, proactively that they were in compliance with that Morton Act. And this was a concern, of course, for survivors. It was a chilling effect on their communications with advocates at rape crisis centers. And you know, we understood that, you know, these attorneys were worried about, you know, attorneys worry a lot, right? I'm one of them, I get it. They didn't want to lose their law license. They didn't want to get in trouble. And they were very concerned about this idea of a privilege law that would keep out potentially exculpatory evidence in a criminal trial. So they were not happy about the idea of this from the get-go. And ultimately, we had a whole list of other priorities that we needed to focus on that year, and we took a little break. And TCFV was very successful in their efforts at getting their privilege bill passed. And finally, this last year, we decided time was right to finally ride the coattails and get this passed into law. So Senator Perry agreed with us and worked very hard at getting this done so that now we have a privilege that also exists in many other states. And it didn't seem to make a difference. You know, if you're a domestic violence victim or a sexual assault victim, you should have the same high level of privacy protection. So that's what this law basically aims to do. So next, what this law does is to build on Chapter 420 of the Government Code. What it does is it takes out the provision that allowed those attorneys to have this blanket authority to subpoena records and get them in under, you know, the possibility that there might be exculpatory evidence. Now they really have to have a firm grounded belief that this evidence exists, and we provide a very narrow pathway for them to do so. But it's all under seal, and we'll get into the details of that later. But this is a big way that this law of confidentiality changed and really beefed it up to make it more of a privilege, of a qualified privilege. So it also includes a partial waiver provision, and we'll talk about that a little bit more too in a little bit. But what that means is that disclosure of part of the information doesn't mean disclosure of all the information. You can just waive part of what you want to disclose. So this gives survivors control over how much of the information that they really want to disclose. So we felt like these are some small but very impactful changes that were made to this existing statute. So we want to turn next to when it began. And as you're probably aware, this law did take effect on September 1, as many of the laws do, but it applies, we want you to know it applies to all communications that even existed before September 1. So if it's a case that comes in front of your court, you know, anytime after September 1, you can look at and have this privilege apply to any communications and records that were shared even before September 1. So it's backwards facing. So that's nice, and it again provides that higher level of protection. Looking at who the privilege applies to, this privilege applies to all employees and volunteers of a sexual assault program. And that sounds fairly simple, but the key here is how a program is defined. I have had a lot of people ask questions about this because there are many, many agencies around the state that serve sexual assault survivors in a number of ways. But it's important to note that this law specifically just applies to those programs that meet those 5 minimum service standards that we have that define what a sexual assault program is legally. And specifically, these minimum standards include a 24-hour hotline, crisis intervention, public education, advocacy, and both legal and medical accompaniment. So if a program provides all of those services and also offers OAG certified training to their staff and volunteers, then it qualifies as a sexual assault program and it's covered by this law. So that's essentially the extent of who this law can apply to. If you have a program that doesn't meet all of those services, maybe you're just a legal services agency, or maybe you only serve trafficking survivors and you only do some crisis intervention, unfortunately, this law does not apply to those programs, even though maybe it ought to, but it is limited, and it only does apply to sexual assault programs specifically. So it applies, the privilege applies to all records and communications that are shared during the advocacy process and shared by the survivor specifically. And it expressly does include confidentiality of records, not just communications. This was a new change, and it includes anything that's shared during advising, counseling, or assisting the survivor. So it's very broadly written. It's intended to include everything, every piece of information that is shared by a survivor to an advocate, and also to the program in general, anyone who might be assisting that survivor. So hotline, calls and, counselors and just anyone who might show up to the hospital to talk to that survivor. It applies to all of those people and all those pieces of the program. So the best part about this privilege, in my opinion, is that it transfers the power of disclosure to the survivor. The survivor holds the privilege. So this law puts the right of privilege in the hands of the survivor and is very survivor-centered in that way. And that's just an aim that we have at TAASA is as we're creating new laws, we want them not only to be setting up trauma-informed services and best practices, we want them to be very survivor-centered. So if the survivor wants to waive the privilege, they can waive the privilege. And if they just want to waive a part of the privilege, but not all of it, they can do that. And the important part here is that they get to choose. They have the right, they own those records and that communication. And this exists in all proceedings. It's very broadly written. It applies to civil litigation. It applies to criminal cases. If in administrative cases like Title IX, like workplace disputes, and also legislative. So, we just really wanted to cover the waterfront on that and make sure that there was no exceptions to where this might apply. But speaking of exceptions, there are some. And again, these are exceptions that mainly did already exist in the confidentiality statute. We didn't take any away. We more concisely organized the way that they were worded in some ways. But most of the changes that we made to this part of the statute were non-substantive. The one big thing we changed was the piece that applies in criminal cases. And we'll cover that at the end of the list of exceptions. So first, I'll talk a little bit about if a survivor decides to sue either the advocate or the sexual assault program, that's an exception to privilege. And so that's only going to be an exception to let that information in if the information is relevant to that person's claim or defense. So, we want to keep it very narrowly confined to make sure that only just the bare minimum gets disclosed, right? And again, because we hold such a high regard for privacy, we don't want to divulge or disclose more than is absolutely necessary to prove a case or to defend against a case. And so the second exception is similar to that, right? So we're talking about if the survivor waives the privilege and only the piece that might be relevant to the case could be then allowed into the court proceeding, only if it's relevant. So again, the survivor waives the release of information, so they've made it public, then the advocate's not bound to keep it private, but only disclose just that amount, that bare amount that's relevant to that case. So the next set of exceptions have to do with mandatory reporting. So if an advocate has reason to believe that a child, and if you don't mind switching to the next slide so they can follow along, thanks. And so if an advocate has a reason to believe that a child or a person who is disabled or elderly has been abused or neglected, then that advocate has to disclose, has the duty, legal duty to disclose that information, as we all know from these statutes in the family code, but only, again, the bare minimum that has to be reported to show that reasonable belief. So, and again, if there's any thought that survivor is going to be a physical danger to themselves or to others, then that needs to be reported. Only the amount that has to be reported. Also, if there's a situation where there's an audit, a financial or programmatic audit or an evaluation or some sort of research project being done, this information can be disclosed but needs to be redacted. So we don't want to personally identify a survivor when we have an exception that applies it in this case. So just make sure that information is redacted when it's shared. And so moving on to our final exceptions, we have if an employer or volunteer if they're working together on a case, if they need to share information with one another in order to provide services to the survivor, then they can go ahead and disclose information to each other, again, as limited as possible. And so here we are to the very last exception, which is the big one that made the huge difference to me in this to make this an absolute, not an absolute privilege, a qualified privilege. So we used to have section 420.074 in the government code, which allowed the prosecutors, defense attorneys to subpoena confidential communications in criminal cases. So that was repealed. That means it's gone. It's not in the statute any longer. And instead we have this exception, which provides this narrow pathway for attorneys to get that information that might be exculpatory into court, only in criminal cases. And so it states that when the communication or the record is in the possession, custody, or control of the state, and a court believes or decides after an in-camera review, that means just under seal in their own chambers, they've looked at it, and they agree, they believe, okay, this information is exculpatory. In other words, it supports the fact that the defendant might be innocent, then only that specific portion of that communication can be disclosed into the court. So it's a very slim and very necessary exception in order to comply with the Michael Morton Act. So that is still there, and that's simply something that you need to know about, because while we recognize very few of these cases do end up going as far as a full court proceeding, a lot of these are pled out if charges are even brought at all, right? But for those that end up in court, it is important for them to know that this is a possibility. So always letting your survivors know that this exists. That's part of your job in preparing them for what's to come in the courts. That this is a slim possibility, some information, if it's exculpatory, meaning it supports that defendant's claim of innocence, it's exculpatory, then it could possibly be brought in, but only the bare minimum of people are going to see that information. So, hopefully that won't chill the communications as much as was in the past. So, essentially, that's the sexual assault bill, the privilege that now exists. And so, I'd be happy to take questions now, or if you wanted to take them at the end, we can certainly do that as well.
I think if it's okay, we'll wait till the end.
Great.
So we'll cover our bill and then we'll open it up to questions or our privilege statute. So I'm going to kind of cover this similar information as Liz just laid out so wonderfully, but again, our privilege statute, which is chapter 93 of the Texas Family Code, and it covers the definitions that I'll walk through right now around what is a victim, a family violence center, an advocate, and then some exceptions to our privilege law as well. So at first, it does apply to the privilege applies to a family violence center. So to define a family violence center, that is a nonprofit a public or private nonprofit organization that provides as its primary purpose or one of its primary purposes is services to victims of family violence. There is a very specific list of services that are included under Chapter 51 that define what a family violence program is. More than likely, an advocacy program in a law enforcement agency or a district attorney's office would not fall under this definition of a family violence center. And then to define who an advocate is, who this in this privilege law is anyone who is employed or volunteering at a family violence center. So again, similar to Liz's statute, but for ours, they only have to have 20 hours of training. And so we do suggest some topics, and some are required by the Texas Administrative Code to be included in that 20 hours of training. So we've listed some of those codes that outline the topics that must be covered right there. It uses the word advocate, but again, keep in mind that that doesn't have to be in the job title of the staff person, and so not everyone has advocate in their name, but as long as they have the 20 hours of training, they will fall under this privilege statute. And we highly suggest that everyone get the training because you still have prevention staff who will be going out into the community and might get outcries out there and disclosures. Your IT and data staff are seeing information that's sensitive, that's being collected by your program. So no matter what the job title, if we suggest they have the 20 hours of training, so they fall under this definition of advocate. What is confidential communication? So under our privilege law, confidential communication is anything that is written or oral between an advocate and a victim that's made in the course of advising, assisting, advocating, and counseling. So again, that language looks very similar to what Liz shared and is very broad on purpose to cover any type of communication that might happen between an advocate and a victim. And then what is privileged is that communication, right? So any of that, anything that's provided while assisting, advising, counseling, written or oral, is the privileged communication between the survivor and the advocate. And just as Liz explained, that privilege belongs to the survivor, right? So that privilege is held by the survivor or the victim, and in the absence of the survivor signing an ROI, the advocate will assume and claim that privilege. So nothing will be shared unless you can get a hold of that survivor and share if they would like to. It would like you to share any information. So again, that is owned by the survivor. They have the choice to share with whoever they want. And if you can't get a hold of them or they say no, then privilege stands. So very similar in those ways. And then I'm going to pass it to Molly to talk about the intersections.
Yeah, absolutely. And I'll welcome Liz. And part of the reason y'all look so similar is Liz gives us too much credit because she helped in every way with the drafting. We got to spend time together many years ago. So I think it was a lot of great brains, and our partner Chris, who's not in this state, but really thinking about how can we take from every state, like if we're going to be number 39, y'all, how can we take all 38 of the best to come to ours? So I think a lot of the thinking that went into ours was shaped together about what all can we cover. That said, in a moment, I'm going to go over our exceptions. And so we do see there's absolutely times where you're a survivor of domestic violence and a survivor of sexual assault. And we want to acknowledge that. And then you'll say, well, then which of these might we use? And I'll let Liz chime in, but we say use whichever one offers the best protection. And I don't know, Liz, if you want to chime in, I think there's places where ours does and places where yours does.
Absolutely. Yeah, absolutely. You know, I think that if you are, for example, getting a protective order, or maybe you're fighting with an abusive spouse, over in a divorce or over child custody, I think that if you are a survivor of sexual assault, then, and you've shared information with the Rape Crisis Center, that's also maybe a dual family violence program. I mean, I think you say, no, this sexual assault statute applies. I'm a victim of sexual assault. And I think the sexual assault statute maybe has more robust protections because it doesn't have any exceptions at all in civil cases, unless it's brought against the program, right? And so I think in a criminal case, you may find more solace if you're talking to a dual program and you are in fact both a survivor of both sexual assault and family violence, you could probably rely on that family violence family code family violence advocate privilege. Would you agree with that, Molly?
Yeah, I do. And one of the things, I think Liz has it spot on, and one of the things we would say for our partners sitting in district attorney's office We know that even though these may not directly apply, that I see the names here in the spirit of upholding that privacy protection. The highest when we talk about which one, it all goes back to that safety, the trust, the help seeking. And so anytime we can offer that intended privacy protection, survivors will seek more services likely. They will come in, they will have communication. So we offer that always again in mind with how can we best support a survivor. But I would agree with you, Liz, and we can come back. I'll go over our exceptions and then we can answer more questions at the end about those differences. But I think you'll see what Liz is saying, that and it makes some sense with the architecture Liz mentioned earlier about the government code prior. I think Breall mentioned this, but just in case, part of was the road for domestic violence advocates. We didn't have anything in code prior to the passage of this law. We certainly had the federal confidentiality perimeter, and those are huge. But all the rest of the provisions lied in the administrative code, which just simply doesn't hold the same weight as a statutory provision. So I think it maybe made our road a little easier, maybe a little harder, in that we weren't coming into those parameters before. And then there is just oftentimes many survivors of intimate partner violence have children involved, which means more civil cases, more intersections to be had. So we'll go forward. Y'all keep in mind if you have questions as we go forward. Some of these will sound familiar, I think, again, because we did work really collaboratively. So you'll be like, this sounds like what Liz just said. One of the things we know true, and we're going to go over exceptions. And so this will be much like Liz said, where the privilege still stands and the architecture of the law was meant to understand the nature of services. The first is that I might be like a really great expert on housing. That was my background when I was a family violence program. I was not a legal advocate necessarily, so I go talk to the legal advocate. When I was doing community-based housing, I could find any housing, but I might have a good question when it came time to a remedy around a protective order. And we wanted to make sure in a family violence program that I can talk to that person, right, about the case and get the help. And so that's an exception under our victim advocate privilege provisions. The other, and this is a little counterintuitive because typically when we talk about privilege, it's something that sits between two people. Like I like to think of it like the thing in the middle of a circle, right? The two sides owned by the victim, but sitting in the middle of that relationship is support group settings. We know over and over research telling us on the family violence side, and I suspect also for sexual assault survivors, that peer support is one of the single most things you want, especially in an intimate partner violence setting when your relationships, you maybe had to flee, or maybe they were embedded in with the partner who used violence. You're seeking to create new home, new family, new peers, and support group is one of those key places. And so if a disclosure is made in front of other persons in front of the support group, that's an exception as well. Now, practically speaking, as a facilitator of a support group, it means having a really good discussion because, it's only so tight as that we all agree together, right? Like if I had said, I'm going to tell y'all something, but don't tell anyone, that would only be if you held it with me. And so it's important if you're facilitating these to talk about it. But it does mean there isn't the same ability to say, well, Breall said it in front of 10 people, right? It was intent to very much cover this one setting around support groups. Breall's going to move us. Liz covered this so well, I'll just reiterate, in Texas, everybody is a mandatory reporter. And so when these exceptions were designed, we also put forward mandatory reporting of adult and child abuse, neglect, or exploitation under the law. One important clause before we move to the next slide, although it's Breall's like, she's got it. I do this too when I'm on slides, Breall, don't worry. This is the report. This is simply the report. In Texas, we have a duty to make the report. What we often find for family violence centers is that there's requests for follow-up information. We understand CPS and the Department of Family and Protective Services doing so. They have a job to ask those questions. We want to respect that hard role and that hard job and understand our role is not to investigate. We are there to make the report, and then we would need a properly issued release to communicate any further. So this exception doesn't go beyond the mandatory reporting statutes. It stays right at what you have to do under the law and the family code. We're also going to move us to a bit of a more complicated one, and really frankly, the one we have that applies most to the criminal setting. And you always, as those of y'all who have worked in policy, you walk in with the most beautiful policy idea ever, and it's so perfect. And then someone says, I have an idea on your idea. And sometimes that idea is good. And this one made me afraid, and sometimes it just changes it a little. So this was one that came through during session. And we had some really, really strong prosecutors, frankly, who said, it's not so much that I have an issue with privilege. What I'm concerned about is being able to move forward forfeiture by wrongdoing. And forfeiture by wrongdoing is really the simple premise that you shouldn't benefit from a bad act, right? You shouldn't get twice the good from a threat. Most often where you've probably seen or heard this, although I recognize a lot of people who may have experience, so please feel free to chime in with examples. Where a lot of this first started coming up was around calls made from jails or prisons, because you were pretty easily able to obtain evidence of the phone call. So if I called someone here and said, if you show up to the custody case, XYZ is going to happen. And then as a safety decision, that survivor says, I believe that, I've seen violence, I understand that this threat's viable, I'm not going to show up, right? So right there, you have a potential forfeiture by wrongdoing case a prosecutor could bring, because that person's now benefited from that threat. You may say, well, that makes sense in the context of a prison recording, because you could enter that. When it comes with our privilege statute, what they're saying is that there could be an in-camera review of a file to see if there was a documented case of that. Most often, let's say Breall is an advocate. I said to Breall, no, I didn't go because XYZ threatened me. And maybe Breall writes a case note that says, Molly didn't attend due to threat. An in-camera review of the file would allow just that component to be utilized, most likely by a prosecutor, to prove forfeiture by wrongdoing. This is extremely rare. Usually, if this is happening, you're in a community with a prosecutor who's really looking at family violence and moving forward these cases. You are likely working with them quite a bit. So this in-camera review really only applies to the forfeiture by wrongdoing. But when we talk about building trust and building space with survivors, we do want to go over it, right? Because we also know it happens way more than it's brought forward. Many survivors of, I'm sure, sexual assault as well will report that these threats have occurred. What's most unlikely is we'd have file documentation of it. But we want to make sure to go over that. And again, if you have questions, feel free to chat and we'll kind of move on to the next one. The next one, which I think also Liz went over and I think sits in theirs as well, is this idea that if you were to serve as a witness, now that could be in a custody case, it could be to explain the nature of domestic violence, coercive control. Essentially, if you rely on privileged information, whether or not that's an oral communication or a review of a file, and your testimony relies on that information, then there would be an exception that the rules of evidence would then apply. Because essentially said, real simply, you've brought in the privileged information in your testimony. We offer this slide because in general, a best practice recommendation is to have an expert witness. That's someone who maybe doesn't know the survivor, but does know what coercive control and power looks like, can explain why a behavior may not look as one would expect, who can share the way in which a survivor may have responded due to trauma, due to exposure to violence. A fact witness is someone who likely is bringing in that privileged information, because it means I'm going to talk about a great example is of parenting. Sometimes in a custody case, a survivor may say, I understand, but I need someone to talk about parenting. We say generally expert witness because you avoid this potential piece, but I do want to say there are times, as long as we're having really great and informed discussions with survivors, they may analyze the risk and still pick the fact witness. It just means also picking that those facts will then be open to the court. And so this is just one to keep in mind that I believe also, Liz, am I right, applies for sexual assault as well. Is that correct? Y'all have a similar-ish provision?
Sorry, I realized I was on mute. No, we don't have anything that goes specifically to that. The only time it's going to come in if the advocate's testifying is if the survivor has filed suit against the advocate or the program. Okay. So yeah.
And thank you for that clarification. And then Breall will move us. And this one's a bit more of a complicated. It's why we said, civil here, criminal here. The next piece is that if a family violence center at the request of a victim, so again, keeping in mind, this means the survivor has made the choice, releases communication that's privileged for the purpose of a criminal or civil proceeding, then it will need to go to both parties. In a criminal proceeding, this is likely to happen under current discovery laws anyway. So it's something you'd want to be talking with the survivor about, making sure they have that information. It would be unlikely to happen in any civil setting without this provision. And so it's really important that when the survivor discloses it, they're aware of the chain. And this is true in all these laws. Anytime we would say, if I say, sure, you can give it to those 4 people, what are those 4 people going to do with it? This is just a really important provision to explain, because it may seem like, yeah, let my attorney bring that into that, court proceeding. And it's important for the survivor to know that means both parties will have access. For us, though, it's something to have an eye on. For many, many years, we've always said where the file should be going is to the survivor. It should always go to the survivor. We should never write something we wouldn't sit next to you. It's a really great bar to read and say, would I feel comfortable sitting next to Breall and reading it out loud? And if I don't, it shouldn't be in there because it's Breall's file, it's Molly's file, it's Liz's file. And so mostly we say, we hope this clause won't get triggered because it's the victim's choice. And if the victim chooses, the file goes to them. And then this piece is not at play. And it also upholds what we've always said, which is the services are your services, the privilege is your privilege, and the file is your file. And so we should feel comfortable at every juncture with that. But it's still important to note that this piece is out there if another route is considered. Breall, if you'll move us forward. So we've talked a lot about releases, and releases can't just be anything you want, right? It's important for us to have, as we're analyzing risks and we're following these laws, and understanding what is a properly issued release. And so here you've got kind of on the left side, we call that it must be, and these are your federal pieces, right? It has to be written, it has to be informed. Informed is huge, right? One of the big things about informed is, let's say another entity sends a release over to me. Well, how do I know that was informed? Right? A big part of it is walking through, and Breall will talk about this in a minute, in an easy to understand way. What am I signing? What am I signing for? Where is it going? Who's it going to? Who else will see it? When will I get it back? Can I take it back? What piece of information are you giving? So informed is really that discussion about all of this we've talked about today. It needs to be reasonably time limited. Reasonably time limited, usually we say if survivors in shelter, the length of the shelter stay. For most survivors who are in non-residential services or housing, maybe seeking counseling, it's the time by which I'd reasonably next see you, right? So if I see you every 6 months, then reasonably time limited could be 6 months. If I see you every 2 months, reasonably time limited could be 2 months. We want to keep that in mind. We also don't want to ever put a burden on a survivor to say, you got to come in every 2 weeks, right? Like we don't ever want to use that against kind of the free flow that survivors are asking. The other thing is it can never be a condition of service because then it's not informed and I'm not choosing. So if you're like, hey, yeah, as a part of intake, we ask you to sign this release because DFPS might call, that right there, now it's no longer, it's a condition of service and it feels like it is. These are the absolute requirements. The next level requirements, and a lot of these are outlined in the Texas Administrative Code for both family violence shelter centers and non-residential centers, is that it must have one name, right? So if, let's say, me and Liz are seeking something together, you can't sign releases for Liz and I together as survivors. It's my release or Liz's release. The other piece that's huge, and we know for all of you in the coordinated community response realm, maybe you're operating in a domestic violence high-risk team realm, it can only have one agency. You cannot have a release to an entire community collaboration. We know that does present some barriers as y'all work together, but a really great example that we heard from one community and one survivor is my partner was in law enforcement, or my partner was at the Department of Family and Protective Services. My partner worked at XYZ agency. And so if you're only offering a broad release, it really puts a survivor at risk. And so this is a requirement that you can only have one agency. You have to list the specific information. A big part of me being informed is like, what are you going to offer? If you put to talk about my family, whoosh, that's a very large door and a very broad opening for my information. On the other hand, if you're going to talk about the dates I attended class, that's very specific. I understand what's being offered. We also know this is important because usually when we're looking at upholding a privilege, we don't want to make a significant disclosure. The broader we make these releases, the more possibility we have that we've made significant disclosures. And so we want to make sure survivors are able to narrow that information to what's really helpful for them and their families. Again, you have the beginning and ending of dates of the release. That's usually around that reasonably time limited. And then dates and signatures for survivors and advocates, and the right to revoke at any time, right? So a lot of the diligence is on us to get it, but I can call up and say, change my mind, change my mind. You can do electronic releases. We know during COVID, we all had to be very creative about what this all looked like. So even though we've got the dates and signatures, it certainly doesn't mean you can't work to execute those electronically in a manner that's safe and keeps what Breall said earlier about security being different in mind. And Breall, if you want to move us forward. She's like, no, we're going to revisit that file, y'all. In terms of a best practice, so this is, that's what you're required to. This is what we suggest, especially since we've been doing so many virtual services. It's really important as a best practice to specify means of communication. If you have a survivor experiencing technology facilitated abuse, we want to be really careful of the ways in which we're communicating. So they may say, I'm all right with a phone call, but I'm not okay with email. That's been compromised. And so usually in our model release, we say specify which way you're agreeing to these pieces of communications occurring. Your technical requirement is to have one agency. Definitely we require if you can name the specific person, that's better. Like imagine if you put the Your Texas benefits to call about benefits, that's like 4,000 people we're putting as a maybe on that field. That said, we know there are times if someone comes in and says, I have a DFPS case where I don't know their name. So this is a best practice to keep it limited, but certainly not totally a requirement. And of course, we want to discuss risks. One of the great things we've heard some of the advocacy leaders like Jill Davies and Eleanor Lyons say is, as advocates, one of our best jobs is to analyze risk, because from that, a survivor can make an informed choice. And so when we're talking about these releases, certainly we want to talk about the benefits, which is clear by all the partners here in the room. And on the other side, what is the risk? Because then I can make my best choice. Thank you, Breall, for continuing to be our slide person. And I think this is the last piece before I give it back to Breall. The other thing we want to keep in mind is I know y'all's jobs are hard. It's been a number of years as an advocate, and I was a community-based advocate as well. Sometimes getting releases was like a 3-hour drive tour of every neighborhood in Austin. But releases are meant to be survivor-centered and not center-centered and not partner-centered and not ease of life-centered. And that's because privacy has all the seriousness we've discussed, because it could be your safety. It could be the last or first time or continued time I seek help. And so we usually say to keep in mind that survivor-centered. And no, it's a bit harder, but it means we're doing everything we said around holding the victim as the center of the conversations and the driver. And then, of course, when we talk about whether or not something's a condition of service, we always have to be careful of the power we hold. Sometimes we say, if you're a shelter advocate, well, did you know you're the landlord? Did you know that that implies something? If you say, it's a great idea to sign a release on, then that power imbalance could read like, you should do this. The same is very much true of our justice system partners. We know many of y'all here are working very hard, but everyone's perception of authority in the legal system is different. And so when y'all make a suggestion, that same power is held. And so we always say that when we're talking about releases, to give really the facts and be aware of a power imbalance we hold. And so we just have that in mind for releases. And then I do think Breall's going to say it. So one of the things we say is like, at this point, people are like, I get it, or whoa, this is a lot. And how am I supposed to explain this? So I'm going to turn it over to Breall to talk a little bit about that.
Yeah, we just wanted to point out one resource that we have, which is really just providing a takeaway. Like this is a lot of information just for us to explain in an hour and a half. So think of being the survivor at intake, learning all of this. So we do have a takeaway that explains a lot of the survivor rights here. And we also have one in a palm card. And so just offering that you can talk about this at any time, bring it up at every meeting you have with the survivor, and let them know that of course questions will come up, so you're open to talking about it again. You know, I always used to say to the students I worked with, like, ask a question as many times as you need to. You know, I'm never going to judge or say anything about having to repeat myself. Like, that's not the point of me being here, right? And so I think making that as clear as possible, and then offering a resource like this so that they can read on their own time as well. It can be really helpful. And then one last note is we recognize at an ICCR, there's a lot of community partners working together. So having proactive conversations around privacy and confidentiality requirements early, and having that in writing so people can understand your role as a family violence program, or what how you can request information as a community partner, can be really beneficial to be proactive about that. So and I want to recognize we all have share the same goals of victim safety and offender accountability. And so how can having a memorandum of understanding to provide guidance around what these look like, what these the confidentiality and privilege obligations look like, and the process of information sharing can be really helpful to have those on the outset. So I'm assuming y'all have something like that if you're part of a community coordinated response, but just wanted to mention it as an option. And then I do want to do a time check, Molly and Liz. We had an activity in here and we have 23 minutes left. So do we have time to talk through this? Yeah.
Yeah, I think we have like a luxurious 7 minutes before questions.
Okay, great. Yeah, and I don't see any questions in the Q&A anyway, so feel free to put those in the Q&A while we go through this scenario. So I'll read it and then I'll pass it over to Molly and Liz to kind of debrief. But you go to a monthly CCR meeting and a case involving a survivor you are working with is on the agenda. The victim assistance coordinator says she knows the survivor is receiving services at your agency and would like an update from you. What are your next steps?
And if folks want, we'll keep this slide up for a minute, because I like I said, I see a number of names I recognize. It's really clear by your dedication to coming today that we have a lot of folks who do think about this quite a bit. And we know in the ICCR that this is something that you're faced with a lot. So we'd love to know in this instance, what would be your next steps? I know it takes a minute to chat, so we'll just wait. And certainly you can also say, this has happened to me, but I'm not sure which is why I'm here. I know we were sharing before we started, many of us are from smaller towns. So it's pretty common that something like this would happen, especially, and I know for the folks here in more rural communities, that can happen quite a bit. I think while everyone's thinking, Breall, we'll do, oh, look, now it's coming right when I say that. It's like I invoked it.
That's right.
Oh, now we have so many good replies.
Mm-hmm. Yeah, like the signed release of confidential information, HIPAA compliant. That's
yes. And the idea that they'd know in advance, right? Yeah. Mm-hmm. I'll get back with you on that. I like that friendly reply. Like, you're not saying anything. You're just like, I see that question. Good question.
Yeah. Have to check for an ROI. Yep. I think everyone's getting it.
Yeah, and a sign release, certainly HIPAA, and even we always say HIPAA's here, and then our federal laws are here, and then privilege is up here. So yeah, making sure you've got a release that covers all of those pieces. Yeah, and Sulan, yeah, explaining the limits, right? So partners understand, because like we said at the beginning, we all come with the spirit of helping families and survivors. So when we're honoring that and saying, you know, I honor your job, here's mine, here's the limits for me, it really continues to create the bridges that the coordinated community response teams are hoping to do. Yeah, thank y'all so much. And many of y'all got this. We'll kind of switch. Breall's got a slide coming up where we'll go over it, but y'all kind of got like, is the client's information privileged, right? And Breall gave us a clue. And the survivor was at a shelter, so we got that clue in that description. And did we see an exception? Not yet, right? Like not on the face of that question, did we have anything? Certainly it's good for us to examine, but in that description, we didn't have one. What are your release protocols? And everybody really got that. That was exciting to see, to say I'd have to have an RA. I like that. I still like that. I hope I would have already had it, right? Because as a coordinated community response team and high risk teams, we know a lot of times there's forethought for the conversations that are going to occur. And then one of the things that we talked about earlier is contacting the client, right? Contacting the survivor, because under our federal laws, we are charged with that reasonable notice and ascertaining what the survivor wants. And Liz did such a great job of explaining that it's theirs, right? Like at the end of the day, this privilege is, we hold space for it, but we don't hold it. They do. So we want to contact them immediately to see what they would like. And then I think you all have talked about it, but like one of the things we can do though in honoring our partners is doing exactly what was pointed out. Let me share the limits. I honor your jobs. I'm excited to be here. I can talk about dynamics, really having that relationship building, and then seeing if the survivor wants to. There are times a survivor absolutely will want to around coordinated community response, high risk teams, because it supports them, but having that conversation. So y'all did a great job of all those questions. Liz, Breall, is there anything else y'all want to add? Because I think we're going to move to questions. Anything else?
I think you covered it.
So now's the time. We see some questions, but if you're even sitting there saying, I'm just not sure about that one thing they said, this is a great time to ask questions or about practical application. I wonder, Breall, if you want to take that first one about text messages, maybe? What do you think?
Sure, yeah. So I think text message, if it's the way the client prefers, I think there are ways that you could do it safely. I think there's a lot of questions that you would want to ask with the survivor around safety, like how will you make sure that it's them on the other end? What device are you using at your agency? Because we don't want advocates to be using their personal devices to be texting. And so I think there is ways to do that if it is what they would prefer, but you want to be able to balance the privacy and confidentiality and safety along with access. So that's my short answer to that.
Yeah, and I love, we kind of like, when tech first came out, we were like, just don't use it. And then I think we've now come to like, okay, we're all using it. So I think that answer of like having the conversation and navigation about what people want, and if they understand the risk, that choice, I think it promotes a lot of survivor autonomy of what we're using.
Yeah, and there are platforms to text, there are ways, a lot of people have hotline numbers now that you have text and chat included. And so I think that there are different tech platforms that make it possible as well.
Let's see, Leslie had a good question about it. It was mentioned that an expert witness who doesn't know the survivor is best for outlining abusive behaviors for court. What issues or bias might arise if the expert witness does know the survivor? I mean, and maybe a clarification or if someone, I mean, I think the big issue around privacy, which doesn't fully answer the question, is once you're up there and you're opening the door to questions, it could open the door to questions about information the survivor did not ask you to go up there to testify about, right? So once you walk up there, you can't say, well, not that one and not that one. So I think that's where some of it comes in. And then we know, gosh, survivors seek amazing counseling services, and they talk about parenting and recovery and used in court in a manner that isn't showing how amazing the strength is. It can be used against a survivor to bias. I don't know, Liz, Breall, if y'all want to offer more on that one.
No, yeah, I think that's absolutely right. And, you know, there's a sense, certainly when there's a jury impaneled, that the expert witness is a neutral, is not somebody who's coming in as like a character witness or anything like that, that they are just presenting facts and evidence and, you know, science. And in this case, if it's a personal friend or just somebody who has a personal relationship in addition to being an expert, that line gets a little blurry, right? So as Molly said, you know, more information could be brought in if you don't have a strong prosecutor objecting to that, to some of that, and keeping it squarely in the confines of an expert witness testimony. But also, you know, the risk is that the jury might go, yeah, but is this really science, or is this just a person who's making this up to support the survivor in this case because they've got this relationship? So I think it maybe wouldn't be as trustworthy by the jury because it's not a neutral situation.
The next question, what if a survivor wants to release or it's time sensitive but can't provide a written release? And I think that was something that was like a very minor occurrence before the pandemic. And then bang on March of 2020, we sure had to find routes to execute releases in a different manner. You know, I think there's a lot of ways in which certainly after having an informed discussion about technology, it provides a lot of avenues for properly issued releases. Certainly, again, having that conversation. I know a long time ago, someone said, no electronics, nothing else. You can't do it. You only have a phone. What can you do? And, you know, and definitely Breall and this time in laws didn't think of everything, right? They give you like this really like either a set perimeter or a broad perimeter or confidentiality. It's pretty set, but it's not like they thought about the day in which a pandemic would occur. Or they thought about a survivor with an emergency situation in a 200-mile away rural community. And so usually we say, you know, assuming you are positive it's a survivor, right? So Breall kind of talked a little bit about a text message, but, you know, can you FaceTime? Do you recognize the voice, right? So let's make the assumption you're able to ascertain that you can do it an emergency orally over the phone. You make a note that you did it and initial it. And the very next time you see them, you have them execute the release. That's the best practice our partners at the National Network to End Domestic Violence put forward. But you're not going to find it in any law, right? Because it didn't contemplate that particular scenario. I don't know if y'all want to add anything to that. I think it's one we faced a lot in the pandemic.
Absolutely. Yeah, I think you said it exactly right. And it's just so important to have it in writing at some point immediately as soon as possible, because, you know, it's a protection not just for the survivor, but for the program, really, for any miscommunications or anything down the line. And so it really is, it's just a necessity. And that's something that just, you know, could be explained maybe as you're talking to the survivor, how important it is.
Yeah. And our last card, our last question so far, unless people have more, you know, there's still time, everybody, is where can you find the takeaway in the palm card? Is it in multiple language? So for us, we don't ever put out resources that are in English and Spanish and then quickly evolve them to Arabic and Vietnamese. So the privacy document Breall showed we have in all 4 languages. We have in Arabic, Vietnamese, Spanish, and English. We are rehabbing that website. It's going to come back better than ever, y'all. So email probably Breall would be the most responsive as I seek to locate all of them. And then you didn't show the pump card. It was
I
our
didn't.
translated document, correct?
Yeah, yes, that one is the one we have in the 4 languages. So that's the one I would probably lean on.
Yeah, we have model releases as well. Similarly, when we're developing forms or resources for survivors, we seek to do the top 4 languages in Texas at all time. Certainly, we're happy to hear more if we need more languages, but we generally speaking do any of our model forms, templates, and again, Arabic, Vietnamese, Spanish, and English. And so we're happy to offer those, and soon happy to offer a link to everything. Someday, soon.
It's exciting.
Yeah.
Who knew web remaking a website would be what takes the longest time.
Yeah. Yes, TAASA did that a few years ago. It was painful.
Well, I don't see any other questions. I know before I turn over to Liz and Breall, I'll say, like, we really appreciate everybody in the room. We know coordinated community response work can both be the hardest, right? Because we're working across all of these disciplines with, especially around privacy, different codes. Like we talked about ours, we know y'all have them, right? We know almost every discipline here has a code they're going by, and that sometimes they'll look like they're overlapping, sometimes they look like this. And so the heart y'all are putting in to what I do think is shared across every set of privacy codes, which is the family, the survivor, the safety. We appreciate everything y'all are doing in communities across Texas to support survivors of both sexual assault and domestic violence. And it's a distinct pleasure to be here with Breall and Liz today after all these years. So we're excited. We just like sharing our excitement about privacy with y'all. I'll let Breall or Liz offer any comments before we turn it back to Becky and AJ.
Well, just thank you for being here and thank you for all you do.
Absolutely. I couldn't say it any better. We are just so appreciative of the work y'all do. You're really on the front lines, getting the hard cases, and we're just here to try to support you as best we can. I know that TCFV is available. I'm available. Our team is available to answer any questions, anything that comes up. Please do reach out. Don't hesitate. We're here for you, and some of these are complicated. These are complicated situations that come up, and sometimes there's not a clear direction. But as we talk through it, usually we'll find a solution. So just reach out, look at the presentation, and all of our emails are there. So we're here for you.
Thank you, ladies, so very much. Liz, Molly, and Breall. Thank you for sharing your time and expertise with us. As you said, Liz, on this really complicated and sticky issue that seems to change with every season. So thank y'all for bringing us all up to date and helping to clarify so much great information. For those of y'all that are joining us on the attendee side, thank y'all so much for joining us. Please watch your email for the webinar evaluation accreditation certificate and the recording of today's webinar. That's it for us, and hope you all have a great rest of the week. Thank you.
Thank you.
Thanks.